Judges play a direct role in the making of law, both here in the United States, especially those at the highest levels. But how do judges get there?
The layperson may be surprised to learn that there is no formal selection process set out in the Australian Constitution. Section 72 merely states that the justices of the High Court shall be appointed by the Governor-General in Council. But what does this look like in practice? Effectively, the Governor-General will rubber stamp the nomination of a candidate who is deemed fit by the executive government, that is, the Prime Minister and the Cabinet of Ministers. There is an additional requirement under Section 6 of the High Court of Australia Act 1979 that the Commonwealth Attorney General must consult with the State Attorneys General before an appointment. This mandate has been criticised as being uniformly disappointing and largely empty. This is because the provision requires mere consultation, not approval. Consultations can occur in private, meaning they can be cursory. All in all, there really isn't much needed to be a judge eligible for appointment, except that they must have been a lawyer or judge for at least 5 years.
Even with these minimum requirements, the executive is largely unrestrained in its decisions, and the process has been described as an opaque system that lacks transparency and genuine political accountability. There is no need to inform the public of the reasons why a High Court justice is selected. Media coverage is often almost non-existent outside of legal circles, and judges maintain relative anonymity whilst on the bench. In short, the process of appointing Australia's most powerful judges remains shrouded in mystery, conducted behind the closed doors of ministerial offices. This leaves the judicial selection process vulnerable to corruption. After all, how will we know what happens?
I stand before you today to fulfill one of my highest and most important duties under the United States Constitution, the nomination of a Supreme Court Justice.
Despite a shared history, America's judicial appointment process is starkly different to ours in many ways. A broad outline of the Supreme Court nomination is stipulated in Article 2, Section 2 of the US Constitution. Unlike here in Australia, the President must obtain both the advice and consent of the Senate before a nominee can assume judicial office. In summary, the President nominates a person for appointment and the Senate makes a final call. In order to obtain Senate approval, the nominee must run a political gamut with standing, scrupulous Senate nomination hearings, chaired by the 22 members of the Senate Judiciary Committee. After extensive questioning from senators, the full Senate votes on whether to confirm or decline the nomination. Only a simple majority is needed.
What makes a judge qualified for appointment? In Australia, we boast use of something known as the merit criterion. Simply, we only appoint judges who have demonstrated merit, and we appoint them only on that basis. But merit is a slippery concept. What even is merit, and who do we rely on to determine it? Merit has been argued by some to be based on experience or knowledge, but others contend that perhaps similarity to one's predecessors plays a large role in differentiating those with merit from those without. Some scholars and writers propose that when looking to appoint judges, mostly old, mostly white, and mostly male cabinets don't look for merit, they look for mirrors.
He needs a mirror, that's what he needs.
This alleged focus on merit, called the merit myth by some, is problematic in that any given case, there is not likely to be a single best person most fit for the job. In such cases, what can be relied on to break the merit stalemate, other than personal or political characteristics?
It's not really possible to appoint Her Honour Justice Jacqueline Gleeson without noting that she is the eldest daughter of former High Court Chief Justice Murray Gleeson. That places her in a rather unique position.
Another issue is that the constituents of merit have also historically been determined by those same older white men, meaning that even where merit is judged objectively against a standard, appointments cannot be objective because the standard itself is unfairly designed to advantage the same type of judges, with precious few breaking the mould. Even though the merit criterion presents issues of its own, a named criterion may allow for better focus on ability separate from politics, and thus a fairer appointment process than in the US, even if in name only.
Politically speaking, Republican presidents tend to appoint more conservative judges to federal judicial office, with Democratic presidents tending to appoint more liberal judges. This is a judicial appointment process which is inherently political. President Obama's attempt to nominate Judge Merrick Garland, who was widely considered a highly skilled judge and centrist, to the Supreme Court in 2016 was blocked by Senate Majority Leader Mitch McConnell. McConnell declared any appointment by the sitting president to be null and void, because the next Supreme Court justice should be chosen by the next president to be elected later that year.
President, the next justice could fundamentally alter the direction of the Supreme Court and have a profound impact on our country. So, of course, the American people should have a say in the court's direction.
Murray Tobias, a judge of the Australian Appellate Supreme Court, speculates McConnell hoped that the forthcoming election would result in a Republican victory, with a Conservative judge filling the vacancy. With a Conservative majority on the Supreme Court, Conservative outcomes would prevail for the indeterminate future. A single president can determine judicial outcomes and the law for generations, because federal judicial officers in the US are appointed for life.
What has happened is, like so much in modern American life, is there has been an intertwining of politics and the legal profession, so that now when presidents run for office, they say, elect me so that I can put in our kinds of judges, which means that the kind of judge you pick helps you with your voters. And if your voters want a very specific kind of ideological judge, then the more ideological of the judge that you pick, the greater your voters will be happy about you, and that'll keep you in office. And that is true of the senators advising and consenting on these decisions, and true of the presidents who pick them. Well, that means that the people who go into the office, into the Supreme Court, I should say, end up being more political than in the past. There was a period where when an American president would pick a justice, that justice very often would rule in a way that was totally the opposite of what the members of that president's party wanted. It happened repeatedly in American life, and that was a symbol, people thought, of the idea that these issues before the court were being weighed on their merits and had nothing to do with the ideological views of the judge weighing them. Now, where you sit on a particular issue is often determined by where you came from politically.
In Australia, High Court justices are appointed not for life, but must retire at the age of 70, a constitutionally mandatory requirement.
Australian High Court selections don't involve the messy confirmation processes recently seen in the United States, but to argue that they're not political appointments overlooks the fact that they are decisions of the government of the day. Justices Stewart and Gleeson will have a long time to leave their mark on the court, as both are more than a decade away from the mandatory retirement age of 70.
High Court judges in Australia need not be confirmed by the Senate, giving the executive unfettered power. This was evident when the then Deputy Prime Minister, Tim Fischer, promised that the federal government would appoint capital C Conservative judges to replace retiring justices of the High Court. His statement followed and criticised the 1996 Wick decision of the High Court. The former Chief Justice of the High Court, Sir Gerard Brennan, warned that the process for selecting judges impairs the safeguards on judicial independence, where politics become the dominant consideration in judicial appointments, especially when governments seek to wrest court judgments to their own purpose. Ultimately, Brennan argues that the Australian judicial appointment process is inherently political, left to the uncontrolled and unreviewable discretion of the executive government. This compromises the notion of judicial independence and the maintenance of the rule of law. Judges must have professional ability and impartiality in mind, as ensuring judges are impartial will prevent too much power being conferred on Parliament, a sacred tenet of the separation of powers.
Overall, both judicial appointment systems present strengths and weaknesses, with systematic issues such as transparency perhaps raising the need for reform and restructure. Despite an insistence on merit-only appointments, the Australian process can never truly be free of politics, as those in charge of election are powerful politicians with virtually unbridled appointment power. The American judicial appointment process is considered to be even more inherently political, with both arms of government influencing the outcome of a judicial appointment. Despite being used as a safeguard, the requirement that the Senate consent to judicial nominations has the potential to undermine the judiciary through its misuse by party leaders. In order to ensure that further degradation is prevented, structural reform of both systems is necessary. This way, we can continue to look towards our highest courts for fair and just outcomes, no matter who is sitting on the bench.